So let's talk about some other kinds of evidence, and I point to my very first case in this, that really began this whole career path for me, which was Dr. Al-Arian's case. Now, in Dr. Al-Arian's case, I got a 153-page indictment. I read it, and I had to read it 3 or 4 times looking for the criminal conduct. I said, what did he do wrong? And I would flip through the pages. And really what it came down to was he said the wrong things at the wrong time. He was an effective communicator for what is happening to the Palestinian people and about the illegal and brutal Israeli military occupation. So he was an effective communicator, so was Holy Land. I think Noor or someone might have mentioned that in the Holy Land Foundation, they would put up these billboards to solicit donations, and there were pictures of the, just the poverty that just defies comprehension in Gaza, and it was just, too good. The message was getting out. The message was getting out. So what happens in Dr. Al-Arian's case in terms of the demonization of the religion and the kinds of evidence? Well, that was pretty interesting because, well, first of all, let me just tell you about the search. This should be interesting. Dr. Al-Arian is a professor, and anyone who's met him knows that he's, I think he's a geek. He's one of those kind of guys. He had 5,000 books. So when the FBI came to his home and took all of his books, they left behind. Now this is searching the most dangerous terrorists. You saw my friend John Ashcroft up there talking about the most dangerous, the financial wizard of Islamic Jihad. Then he was demoted to being a member, and then he was demoted to just being kind of associated with, and then we won the trial. But so they came into his home, and they took 5,000 books on material support of terrorism charges. And you know what they left? They left a gun. And I said, that is evidence that the First Amendment is far more dangerous than the Second Amendment. Okay? They left a gun. We had pictures of the gun, they saw the gun, they looked at the gun, they picked it up, and then they put it back down. And they took all his books. So Professor Gasson, be careful on the kinds of books that you have, sir. You could be in big trouble. All right, so let's talk about very, very quickly the kinds of evidence that they put forward at Dr. Al-Arian's trial. Well, they introduced evidence of a dream. A dream, D-R-E-A-M. And what they said was that somebody else, not Dr. Al-Arian, but someone else had a dream. And this dream involved Dr. Al-Arian, and the dream was extremely negative. And they wanted to admit that in this case. Now, I looked in the federal rules of evidence, and I could find nothing about dream evidence. I just couldn't find it. How do I object to that? It's crazy. Then the government...
Was that admitted?
It was not. We fought hard. We fought hard. Then the FBI, how low can they go? I'm going to tell you how low they can go. They decided they would take a public Heartline bus. You guys must have your public buses wherever you live, right? So in Florida, they're called Heartlines. So they went out to the Everglades. And I get an email as defense counsel one day from the FBI, and they say, we're inviting you to a demonstration that we're going to video and that we're going to use against your client. So we sent one of the lawyers, and she said it was like Alice in Wonderland. It was in the Everglades. The FBI, they were packing heat and what have you. And what they did was they took a Heartline bus and they blew it up. And they sought to admit that as evidence against Dr. Al-Arian. And when we challenged it, what was the relevance of that? They said, well, because, Dr. Al-Arian is a terrorist, there's terrorism in Israel, they blow up buses, therefore don't you get it? And thankfully the judge did not get it. And that didn't come out. The classified evidence issue, very quickly. In Dr. Siddiqui's case, when Charlie Swift and I came into the case, we had security clearances already. The other lawyers who were already in place did not have security clearances, and the government said, they've got to get security clearances so they can see the classified evidence. So they did that, and it's a very invasive, intrusive experience. They go back 10 or 20 years, they talk to everyone. So the one lawyer got the security clearance, then Charlie Swift and I came into the case, and the government then decided, oh, we don't have any classified evidence for you to review. So they played those kinds of games with classified evidence and issues of clearance. With Dr. Al-Arian, I will tell you this. The first time I went to see him, I had my indictment. It was 3 inches thick. The government, the prison people said I wasn't allowed in because they took a ruler and measured, and they said you can only bring in 1 inch worth of documents. I said my indictment is 3 inches thick. I mean, what am I supposed to do? So we fought that and we won. His conditions of confinement and detention were horrendous. And just to reiterate something that Mel said earlier, I want you to get the visual on this. I would sit in the attorney room, and they would lead my client in to see me like a beast of burden with his hands behind his back and documents on his back and hunched over. That only happened a couple of times because we put an end to that. These cases present a host of unique issues and problems. I will tell you that in listening to people and their committees and what they want to do, I'm very heartened by that. I would ask a couple of things as a lawyer in these cases. When these trials are in your cities, come to court, sit in court, especially the ladies who cover. I think it's important. And I also think it's important on these cases that we encourage that there are teams of lawyers who represent these people. These are very difficult cases. Contrary to what I told some very interesting and wonderful and hopeful activists last night, I have a little more hope today, and I thank you.